maybe at 17, they're not going to be rehabilitated. That doesn't say at 45 they may feel differently about. Yes.
It's funny because actually that's kind of what one of my pro bono projects at Berry, because it affects Florida the most. We have like 116 inmates that are going to be that was affected by that decision, and there.
Could you speak up a little bit, just
oh, sorry.
for me and for the
yeah.
people
So
here.
right now we're in the process of trying to figure out of the non-homicide cases who has counsel to put forth like the paperwork for like a reduced sentence. But the issue is like, okay, well, if it's a reduced sentence as opposed to life imprisonment, I mean, if you still get 50 years, that's still like a life sentence. And so like, well, what do you do with that?
If you're 17 and you're given a life sentence, let's say the average age of life is 76, you're being sentenced to 60 years. If I am sentenced to life imprisonment, I'm going to do less than 60 years. I mean, if I die at 75. I'm trying to avoid telling you how old I am. And that was actually something, a consideration of the court, that this is not, it's not equal, and it doesn't mean that they will be released, but to give them the opportunity to change and rehabilitate and then reconsider, and so that they have to be eligible for parole.
I just have a point of clarification. In India, when you say life imprisonment, is that the American equivalent of life without parole, or is that the statutorily defined life for
14
years?
No. Life imprisonment means lifelong.
Lifelong.
Okay.
But
there is
under the criminal procedure code, after 14 years
14
of
years.
serving, you could make an application to the state,
Yeah.
and the state will look into your behavior during the
yeah.
imprisonment, and
Yes.
if you are releasing, what would happen,
Yeah.
whether you are going to cause harm to the victim's family. All those considerations will be considered, and no problem, they will release you after 14 years. But that means every person who is under the life imprisonment has a right to make an appeal after 14
After
years.
14.
In fact, some of my students under the prison clinic, they go to the prison and find out how many of them are about to complete,
And
and
then
they make
move the
applications to the state. But the state could refuse if they really feel that you are a threat to the society.
I just want to make a distinction in the United States. When we say life in prison, there are two types of life sentences.
Yeah.
One is non-parolable, which means you're never getting out unless the president or the governor of your state grants clemency. There's no, the judge has no discretion, and because sometimes in the statute itself says this is the required sentence. Then there is what's called parolable life, and it varies from state to state. Sometimes after 20 years, sometimes after 30 years, then you become eligible for parole. So there's, when I say life, the difference between non-parolable life and a life sentence where after a long period of time, you can apply, again, the government doesn't have to grant it, but, yes, sir.
I have a question. It seems to me India might be a little bit more advanced in one area where the family of the former prime minister was able to get the sentence commuted. I don't know, is that possible in the United States?
It's an issue within families. I can tell you my father was murdered, and within my family, there was disagreement within the family about, you know, someone, my family felt, I can't wait till this person is killed. He's done such a terrible thing. That was not my feeling. I mean, I wanted this person put away, but not executed. So in the state system, you would then, there's a process called commutation, where you petition to the governor of the state, the head administrative official in the state, and you seek clemency. And usually the problem is that the victim's family is resistant to it, and they have a right to come forward and say, no, I don't want this. And even in parole, where the state is considering it, they will get input from the family. I don't know if that addresses your... So there is a process that could do that, and it has happened Some people on religious grounds, they don't believe in the death penalty. They're not saying, I want this person, I forgive this person, he should go on with his life, but we don't want him executed. And
along those lines, Professor Rao, you had said earlier there was a movement against or towards abolition, and in the U.S., churches have been a big part of the coalition that's moving towards abolition of the death penalty. And I'm wondering what role the churches have here in India on abolition. Are they part of that movement?
I don't think there is any articulation coming from the church or advocating for the abolition of death penalty. I have not seen, but I can give you one instance. There's an interesting study conducted. This is in 1940s, before the Indian Union or a federal state was formed. Travancore is a small state in Kerala. So they have conducted a study. 3 years, the Travancore state, they abolished death penalty and they studied the crime rate, and after that again they have imposed the death penalty and they have studied, and they found there is no change in the crime rate. Another interesting study is Nizam is a state in Hyderabad state, in where I come from, now is Andhra Pradesh. Nizam, they say that, I don't know whether on religious grounds or a personal ground, Nizam said no death penalty in the Nizam state.
So what is the Nizam?
Nizam is a Muslim ruler in Deccan, they call, is in the southern parts of India, where part of Andhra Pradesh, Tamil Nadu, Karnataka and Kerala were called as a Nizam state. This was recorded in the Amnesty International document on death penalty.
let me just put, for the Indian students, there is a wonderful movie called Dead Man Walking. And it talks about a Roman Catholic nun who works with the prisoner who is scheduled to be sentenced to death. And she's doing this because of her religious beliefs. But it'll give you some sense of the dynamics of the family. It's a very well done movie, very good actor, some of our best actors. But what you just raised as to the church, because her Catholicism, and actually within Catholicism there's disagreement, but there are certain groups, sections of Catholicism that says we Ten Commandments says thou shalt not kill, and they don't make exceptions. You can lock this person up, but don't kill them, and so it comes from her religious convictions. So, and you're right, it has been a very powerful movement in the death penalty. And also the fact that we're finding more and more people in the Innocence Movement who are factually innocent. So how many people have been put to death who had a terrible lawyer who didn't do their job, and now there's big concern about, and John mentioned the other day, the governor in Illinois said the Chicago Police Department investigation system is so corrupt that anyone who is sentenced to death based on their investigation will have their sentence commuted. The death penalty, they still have to stay in prison, but we're not going to impose a death penalty because I don't trust that they're guilty, and we're not going to kill people. So that was a big change, but those kinds of things are happening a lot.
Yeah.
Sir, what do you think about the political prisoners? Is there any existence in India? Because as we know, many of the third world countries, they are suffering for the existence of the political prisoners for some other reasons or political reasons. But in some situations, when there is some kinds of the agreements will be held between the governments and the other political parties, they will be released by the decision for the president himself. So what about India?
Yeah, there are two aspects in this. Political prisoners mostly during independence, particularly during the emergency, as Ravi has mentioned. In the emergency, several political leaders were behind the prisons, and even now other political parties, particularly Maoists and others, those who are in the prison, they mobilize the prisoners within, and that resulted in supply of prison manual and articulation of new rights, visiting rights. But political prisoners, and the second aspect is release or commutation, that is the governor's decision, head of the state or president of India, and generally during these two important celebrations in India, Independence Day and Republic Day. So the government during that time will release based on their good conduct and their antecedents after that completion of 14 years or even in between. So they will be released. That's a government's decision based on the recommendation from the prison, and you also have a social defense agency. They collect the report, probation officers, we have a probation system, so they collect the reports from the probation officer, and based on that they will be released.
We don't have the political prisoners whom you kept in mind, like
Yeah.
Suki and
No, there's no one.
kind of
Yeah.
political prisoners not there in India.
Yeah.
I won't talk about Guantanamo Bay because that would take a week. I mean, and I'm happy if someone's interested to discuss those cases because it's a very complex issue. I just wanted to mention, before I mentioned that the U.S. has 2,300,000 people incarcerated, by far the most in the world. 95% of them were sentenced by state courts, not by the federal system. And that's where the majority of criminal proceedings occur. They take thousands of cases. In my county, it's a city of, what, 1.5 million, something like that. They may have 20,000 criminal cases that they have to do sentencing on. As to the prosecutor question, the prosecutor in the U.S. has probably more power than any other player in this, than the judge, because the police come to them with their investigation, and then the prosecutor decides what crime to charge. They have that complete discretion, and after that decision is made, and sometimes there's abuse of it, sometimes it's appropriate, sometimes they'll charge 5 different things in the hopes that it will, about plea bargaining, that the defendant will agree to one of the sentences so we won't have to go to trial. So a couple other things about other rights. You've probably heard about Miranda rights, so the police have to tell you that you have a right to remain silent. Search and seizure. If the police illegally take something from an accused person, it can't be used in the court. The right to counsel, to have an attorney for someone who's indigent, and the right to effective assistance to counsel, the right to discovery of evidence that the police have that shows that you didn't do the crime, because oftentimes the prosecutor in the past will provide some of the evidence to the prosecutor, but there may be an interview with someone who said, no, he was with me that night, but it's not given to the prosecutor. Now there's all the changes in the constitutional law that says you can't do this anymore come out of the decisions of the Supreme Court. It's not in the statutes, it's not in the Constitution. It comes from the Constitution, but it comes from judicial interpretation of the Constitution because there were abuses and people were beaten or scared into saying things or saying, well, just tell us what happened and what you did and I'll make sure it doesn't go anywhere. Well, somebody who is not literate or familiar with the system is, if they're only talking to the police officer, the court has said maybe they need to know their rights. And the only way that we just giving them a piece of paper is not enough. So if they say, I want a lawyer, the police have to say you have a right to a lawyer, and then a lawyer is appointed to protect them at the investigation stage, not at the trial, but at the investigation stage. And we've had our Constitution you've had yours since, 1943? 50? Well, about 60 years, and ours is older. But these criminal procedural rights, even the right to counsel, didn't develop until the late 1960s. So there were hundreds of years, I don't know, a while before any of these rights were given to. So it's a really fairly new thing, and the right to the obligation of the police and the prosecutor to give the defense attorney evidence that shows the person is not guilty is within the years. So how many people were convicted because no one knew that there was a witness who said the person wasn't there? So it's taking us a while. We have these rights in the Constitution, but the Supreme Court has developed these rights out of the Constitution because of the experiences with police and state prosecutors and at the investigation stage and at trial. And you have a right to an attorney. It doesn't mean you have a right to have a warm body standing next to you. It means you have the right to effective assistance of counsel. And there are certain standards, and they're not very high in some states. I look at my friend from Texas. There is a case out of the state of, there's a case out of the state Supreme Court of Texas that says a defense attorney who is asleep during the trial, it is not necessarily ineffective assistance of counsel. It may be a tactic to make the jurors, it's frightening to me, because if somebody is in a coma, it could be effective assistance of counsel. I don't think so. Yes?
You may also want to mention the Padilla case.
Sorry?
You may want to mention Padilla v. Kentucky in terms of using
I'm hearing that. I'm sorry.
So the Supreme Court recently decided a case in Padilla v. Kentucky saying that the failure of a criminal defense attorney to advise someone about the immigration consequences of a conviction, because many convictions can lead to deportation, even for minor crimes like shoplifting. So our Supreme Court recently ruled that the failure to advise somebody that they can be deported or have other negative immigration consequences is ineffective assistance of counsel. So this has caused a major change in the U.S. in the sense that public defenders' offices are now, some of them are having in-house immigration counsel, but there's going to be a change in the standards in the U.S. in terms of how knowledgeable about immigration issues criminal defense attorneys and public defenders mostly need to be.
I can tell you, practice was advising people who were not citizens or not advising on the consequences of they'll say, I've got you a great deal, and then the person is deported. Because the criminal defense attorney doesn't know or pretends that they know. And so this case was major because it's actually the immigration proceedings are considered civil, but that may be the most important thing for this person. I'd rather do some time in prison and stay here rather than be deported. But now the court has said, you have to tell this person if it's perfectly clear in the statute.
And what makes this really tricky is that the law is very complicated about what convictions make you deportable, and it's constantly changing because the circuit courts are constantly interpreting like what crimes constitute an aggravated felony under immigration law, which is different than how it's defined by the states.
In the Padilla case itself, it was a very simple. It said the immigration statute, and I'm paraphrasing, says if you're convicted of a drug crime, you can be deported. And the defense attorney said, don't worry about it. And all you had to do, that was not a complex issue. But there is an obligation now, even under the Padilla case, at least in my reading of it and understanding, and it's still evolving, that if it is complicated, then you at least have to tell the person that there may be immigration consequences, and you need to talk to somebody who knows what they're talking about. because that may be the most important. For this man, Mr. Padilla, he was willing to go to prison if he didn't get deported. And he was said, don't worry about it. And that used to be the practice. If a judge said on the record, I'm giving you the sentence, but I don't want this person deported, that the immigration authorities would respect that. That law changed, and it changes all the time. So it's difficult for a defense attorney to know what's the status of immigration law. So when I was a defense attorney, I didn't pretend that I knew immigration law. What I did was find my friends I went to law school with that I knew were smart and practiced immigration law, and I said, what's the consequence? But very few lawyers did that. And for the defendant, it could be a minor. I stole a candy bar from a store. The judge will say, I'll give you a suspended sentence. You don't have to go to jail. And then the immigration authorities take them into custody, and then they start the deportation, and they're held in custody sometimes for a very long time.
I just wanted to maybe just to back up just very briefly, and just that in the U.S. There are between 10 to 20 million people that are undocumented, which means they've come into the United States not through proper channels of immigration, so they don't have the proper stamp, they have nothing in a visa, so they're there, illegally. And so what will happen is that they'll get pulled over by the police for a traffic violation, they'll get put into court, and then someone will check their status and find out they don't have the proper paperwork in their passport, they don't have a passport, and then next thing you know, they're deported back to their home country. And so what happens is that you might have somebody that's actually been living and working in the United States, has bought property, has a family, has a whole life in the U.S., but then because of having, not turned on a turn signal at a stoplight, they are suddenly being sent back home. And so
It's not even their home.
It's not even their home anymore. And so we, generally speaking, some attorneys practice both immigration law and criminal defense law, so they understand both. But oftentimes, like Professor Gear was saying, criminal attorneys know nothing about immigration law very little, and the immigration attorneys know very little about the criminal law.
And the judges know less.
And so if the criminal attorney might get a very good deal in terms of a criminal case, and maybe get a good sentence or a good not very much trouble, but by pleading guilty to a certain type of crime, when they go over, because once they're done in the criminal court, they get brought over to the immigration court, and because they've pleaded guilty to that, that's where they end up getting deported. And this case just says, that's a very simplified version, but this case says that now that the criminal lawyer has to know about all of these things. They have to be aware of what can happen in the immigration court before they couldn't.
Let me just correct one thing that you said. As Mr. Padilla was a legal permanent resident, he was not undocumented. Because he was not a naturalized citizen,
basically exile, right? And then the second thing I was going to say, we'll come back to it. So yeah, so in terms of the right to counsel in immigration, it's a foot in the door.
This case was a big surprise because it was the first time the court had said the defense attorney has an obligation to inform someone of consequences outside of the direct criminal case. And at least I was shocked that they did that, and I think most people were hoping that at least they would have the right to, you had an obligation to tell them to talk to an immigration lawyer. But here, if the law is perfectly clear, and it couldn't be clearer in Mr. Padilla's case, I mean, my daughter when she was 9 could have looked at this, and it said any drug offense, and he was on trial, and he pled guilty because he was told, I will not be deported. And now the case is sent back, and he has a decision to make about whether I'm going to take this plea and be deported, or take a chance and go to trial?
Yeah, Devalas.
Yes, sir.
So you mentioned about the more prominent role of a prosecutor when deciding a particular offense, etc. As comparing to India, the judge has some role to play when police came, arrested a person and came before a court and he's charged some particular offences. Then what is the role of a judge in US to decide?
The role of the judge?
To decide a particular offence, whether he is...
The judge does not charge the crime. It's the prosecutor. The prosecutor decides what to charge and then goes to the court and says, and the case begins, and then the person is appointed counsel. Is that answering your question, or?
Yeah. Whereas
But the judge is not involved. In some, like in Latin America, for instance, the judge is also investigator. In the U.S., they're not. It's totally on the prosecutor. The prosecutor has enormous power.
Here in India, prosecutor only just conducts the case on behalf of the government, and the judge will decide. This is called as cognizance, whether to take on record and commence the trial or to discharge. That power is vests with the judge.
And typically in the U.S., that's not the case unless there's a legality issue. But that's very unusual. For the most part, it's totally up to the prosecutor.
So, to Professor Rao, public prosecutor in India is very ineffective. That's the first time whatever I have observed, at least in northern India, not in south. There is a reason. Public prosecutor invariably is a policeman. Now when I say policeman, police also has got a judicial wing. They have also got lawyers, judges on them. In most of the North India, wherever I have worked, now they are policemen. From police grades, they have grown into be a lawyer and they become public prosecutor. Second point, their reporting, though officially speaking, they should be judicial people, they should be judge, they should be district courts people, but their official reporting is to collector. To collector means they report to district attorney, and district attorney's boss to whom he is reporting is the district collector. So they become invariably ineffective.
There is no professional directorate of prosecution, but some states now they don't report.
In Karnataka, sir.
Directorate
of prosecution.
There is a directorate of prosecution
There is a separate
in several states. Earlier it used to be, but the problem is they are not the police officers. Any lawyer with 3 years or 5 years of experience.
7 years.
No, assistant public prosecutor is 3 years. There are 3 categories: assistant, additional, and public prosecutor. Assistant is like a 3 years who can practice in the who will be there in the magistrate court. Middle level 5 years, 7 years is a 7 years and more is a public prosecutor. So there is a directorate of prosecution system in place, but still it is they have not created a special agency. Now they report to the High Court. In Andhra Pradesh, I know it's a High Court. In Karnataka, maybe a special directorate. But still the process. Now I have several of my friends are public prosecutors. So, but as you said, it is. I don't say inefficient, but they are not able to properly defend.
They don't play up so very well.
That's the reason now there are demands which are coming up. Women's groups say in a dowry violence or domestic violence, they said we don't have a belief. We don't think this public prosecutor will be able to effectively present our case. So therefore, in some cases, court has accepted.
We could continue the discussion, but I promised the director that what I told you in the beginning of the class, that we need a what we call a head count of who's going on the Delhi trip, and we pass this around, and so if you could look at it and then very quickly. But first he needs to get to the transport vendor the information, so you'll have a bus to go on tomorrow morning. Thank you. I'm sorry to be pushy, but I know that Director has the contract vendors, so this is not the Jaipur trip. We'll deal with that separately. This is just this weekend, Saturday and Sunday. And you can see the price difference depends on how many people go, so he needs to know the numbers.
It is only for the places mentioned here. That's another thing to be kept in mind.
Yeah. First day, Old Delhi,
Yes.
second day, New Delhi. So.
If you are about 21%, it is 784 for 2 days.
Any questions about this before we take a hand count?
How long is this?
That's it. You can go for one day, but the price will vary. That we have to again get back to the vendor,
How
transport.
long is this?
Not dramatically, but to some extent. We don't know the answer. But
How much of the day will this tour take? Like, will it be
What's that?
How much of the day will it take? Like, will it be the whole day long, or?
Maybe you may have to, from say 9:30 to 5 p.m.
No, I doubt. They said yesterday when I met them, they said about half day. We have to cross check with them.
No,
Whether there is a lunch break in this?
yeah, lunch break is there.
a good part of the day.
Yeah, good point. See, please keep a margin for that Delhi traffic also.
So talk to the vendor, and this might make it a little more open to you. For Indian students, each day, we're going to have a 35-seater bus. And so if you change...
So this is a case about Neelavati Behra's son, who was taken by the police for the charge of theft. And he was taken on custody, and for the same night, the police version says that he ran, and he ran from custody, and then he was found dead the next day. So this is the case. So what can be done? So the petitioner can file a case under Article 21, which is the right to life, and can directly approach the Supreme Court and the High Court, which under Article 32 and 226 of the Indian Constitution, which demanding compensation for the death, and subsequent civil suit can also be filed under say negligence, which can give more compensation, but the compensation which will be given, the initial compensation will be deducted from what shall be awarded. Because unnatural death is if a person dies in police custody, it will be considered unnatural death until contrary proof. So, and the judge can order inquiries. The post-mortem report shall be given, and the non-judicial protections is that maybe media can help. There are other NGOs, organizations which can come forward and help the mother in filing the case.
And for the U.S. courts, it's similar in the negligence portion, that the mother can file a negligence suit against the police department, which is against the state, and ask for compensation. But if there's going to be any investigation, that's generally left up to the prosecutor's office, and that the prosecutor can do an investigation of the police to find out exactly what happened, and that would turn possibly into a criminal matter against the police as from the investigation. The non-judicial protections are also similar to those available in India, that they're depending on the sympathy of the victim, of the man who died, that the media might give it attention, or there might be human interest groups that spotlight this issue and the community might gather. but none of that is really very set, that it's going to be up to the parent to kind of go to those groups and try and make their son's case a public event sort of thing.
I'm very sorry about this. I just want to make some clarification about lunch. I feel like a camp director. We have to finish lunch at 1, but the bus will not leave to 1:30. But we have to be out of the dining hall at 1 because a different group is coming in, just so you're aware of that. So, but we won't leave to 1:30.
Yeah, because we said 12 to 1 is our lunchtime, so they kept 1 to 1:30 for somebody. Next group. We are having our lunch before 1, we have to finish, and 1:30 we'll be having ours. Hello. This is group 5.
This case is about it is about bail application. In this case, the person who was accused, he was a mason and he was not having very economic efficient background. He was not economically very sound, and when he applied for bail, then the magistrate refused him granting bail because he was not able to furnish the security of bail security bond which he is supposed to furnish in order to get bail. Further, in this case, it has been already decided by the Supreme Court. The court held that because he was not able to furnish the security bond, so he should be released on the personal bond itself, and in the interest of social justice, and also in order to give him equal treatment along with the other citizens. Now, what we are supposed to do, the answers that we are supposed to answer in the particular exercise, the questions, I am sorry, we will be doing it on the basis of the order of the magistrate itself, where his right to have bail was refused. Because ultimately the Supreme Court in this case has held his right and has taken care of the human rights perspective if we talk about in this case, because already they have talked about the equal treatment that he should be given, and the social justice principle is also ensured. So in India, the law says that in case of bailable offences, bail is a matter of right. There is another provision which says that if the person is not able to furnish the security in like a week of making application for bail, it means that he is an indigent person. And further, in India, the rights of indigent persons are protected, but I am not really aware of the legal background that is available in this regard. And the procedure that is to be followed is simple, that if, like in the instant case also it has happened, that when the magistrate ordered not to give the bail and the bail was refused, the procedure is that he can appeal further and further, which goes to finally the Supreme Court is the highest authority, highest court in India. So in this case, Supreme Court has given him bail on the grounds that he was an indigent person. And talking about the non-judicial protection in India, which means that something new, according to me, should be that there should be some kind of governmental or non-governmental agencies, like the NGOs are already working, and maybe there can be some new agency which should take care, which should actually take care of the accused and the family, so that it can be seen that what are the reasons that the particular crime that he is accused of has been committed or not can be found out. Like already this is found out during the investigation process, but since in India the investigation process is conducted by the police and the other officials, which is not really very efficient, because they are highly corrupt and they do not, it does not functions properly in India. So in order to ensure, like if there can be a question that since he is not furnished any kind of security bond, so he may escape if we just give him bail like that. In that particular instance, if we have certain these kind of agencies, then they can, when they are just taking care or they are having the custody of the particular person and his family, then they can also ensure that he does not escape, and ultimately the ends of the justice can be secured by following this mechanism.
I would like to add something that what could be happens in Sudan and similar for the most of the Arab countries, that these situations could be resolved, that to to adopt the system which given the right from the judge to release that persons who is supposed to pay the amount of money by making a compromising with the petitioner party and who has accepted for giving of that release to the various party, but there is some kinds of the conditions and guidelines of the grantees should be taken there. One of these kinds of the grantees that whatever the party who is supposed to pay of that amount of money, he has to promise to the judge that whatever he got any amount of money according to his word or the will or any kinds of the situation that it will be given to him, it will be put the priority for payments of that money to that amount of money for the petitioners. And by this way, when he will accept for that and sign the agreements and the promise for that, he will be released under the condition that to be monitored for, at all. And according for another part that the judicial protections which should be available for the mentioned party at this point, we can see obviously that the interest of the social justice and to ensure the equal treatments to all citizen petitioners should be released on their own bond for the affordable sum of the surety. It will be given there also. But on the other hand, I believe that there is some kinds of the rights which should be under the non-judicial like protections, like giving the priority for the freedom of speech for the first part to explain everything about his financial situations to the judge. By this way, the court can evaluate the case itself and then try to give a reasonable judgments and decisions for that case.
In the United States, the Eighth Amendment clearly sets out that excessive bail cannot be required. The Eighth Amendment doesn't talk about whether or not bail is an absolute right, though. In states like Nevada, Article 1 of the Nevada Constitution clearly says that bail is an absolute right in all cases except capital cases.
And treason.
And treason? I didn't know that.
Article 1, Section 8. They should know this.
So we talked a little bit about bail bondsmen. We don't really have this concept of a personal bond in the States. Typically what will happen is if I don't have the money to pay my own bail, I will go to a bail bondsman and I will give him a portion of the amount of my bail, usually 10%. And that's how I get out of jail. And I asked Professor Rowe when we were talking about non-judicial remedies whether you have bail bondsmen here in India. And his reaction was kind of extreme. He said, no, no, no. And it seems like that concept of a bail bondsman might not be culturally acceptable in India. And they talked about you would call your family or friends to put up surety for you, whereas my family would say, Kendall, go get a bail bondsman. So if this Mason who is making 250 rupees a day, which is what, $5 US?
Yeah, 5 to 6.
If he wasn't able to pay in the US, there's a possibility that he might sit in jail. But we also have something called releasing somebody on their own recognizance. And so it's kind of like a personal bond, but not really, because there's no money involved. What the judge will do is they'll look at the character of the person, whether or not the person works in the community, has family in the community, or something to really tie them down to that community so that they're not a flight risk. And being that this guy is a Mason, it's really going to weigh heavily on the judge's mind. The judge is probably going to think that he has strong ties to the community, he's a good character, and he would be released on his own recognizance. I think that's pretty much everything we discussed.
Yeah, no, I could add one thing about bail. In lesser crimes, we have a concept called personal recognizance, where the judge can release you if you have close ties to the community, you're employed, and the judge is not worried about you returning to the court.
Or you're a danger to the community.
And we have a problem in India is now they actually proposed an amendment to provide the power of granting bail to the police officer themselves. That means you need not go to the court to get a bail. The moment the police arrest you, the police will tell you it is a bailable. If you can provide the security, we will release you. It's a time out. So you need not be produced before the magistrate. But there is a lot of resentment from the public that we don't want this kind of power to the police.
So the police has
No, in bailable bond they have to be. But what happens in most of the time, police may not inform you that you have this. Or they may inform only to the people whom they want. And there could be a chance of misuse. Therefore, there is a lot of resentment and the amendment was not carried out. And the bail bond, what Kendall spoke, is something that we need to think about here, but not in the matter of paying.
Self-bond is here.
Self-bond is there, but I don't have that much money.
No, self-bond means
Judge can release without any money, but what is the guarantee that he will come back?
You take the one in my case.